Excellencies, distinguished delegates, colleagues, my name is Marcos Orellana. I am the United Nations Special Rapporteur on Toxics and Human Rights. This is a special procedure of the Human Rights Council tasked with monitoring and reporting on hazardous substances and wastes in the understanding that exposure to toxics can result in a range of human rights violations and abuses. I am very pleased to join the 16th meeting of the Task Force on Access to Justice of the Aarhus Convention. Today, I wish to share some information on my upcoming thematic report on access to justice and effective remedies in the context of toxics. Why this theme? There's one key reason that I think is also relevant for the Task Force on Access to Justice of the Aarhus Convention, and that is accountability and the need to overcome obstacles to access to justice that often result in impunity. To illustrate this, I will elaborate on the Arica case. The basic facts: in 1984-1985, the Swedish company Boliden shipped nearly 20,000 tons of hazardous wastes to Arica. Arsenic, mercury, cadmium were present in the waste. The waste ended up dumped in the middle of the city. The Arica community has been exposed for decades to the hazardous substances with various impacts, numerous deaths from cancer, women unable to conceive or experiencing miscarriages, children suffering from birth defects. The toxic wastes are still out in the open, exposed to the elements of nature. In September 2013, 796 Arica residents brought a legal case against Boliden. The district court in Sweden held that victims failed to establish a causal link between the waste and the arsenic in their bodies. The Court of Appeals held the claims were time-barred. 10 years counted from the time of the negligent act, and the act was the decision to export the waste. The Supreme Court of Sweden denied leave to hear the case. Now, the case is much more complex, but with those basic facts in mind, here are some observations on access to justice. First, on the role of organizations. In this case, an organization was created for the purpose of taking the victim's claim to court. According to Swedish legal system and the loser pays legal fees, this organization was left with a debt of 3 to 3.5 million euros. As an impact of those legal fees, the organization went bankrupt. So the question arises, is the loser pays fee rule an obstacle to access to justice? Or put differently, are fees reasonable if they result in the organization going bankrupt? Prima facie, the rule and the fees would not appear to be reasonable. Secondly, the harassment of lawyers of the victims. The company, Boliden, sent a letter to the lawyers stating that the company reserves the right to collect legal fees from the lawyers. The company also filed a complaint to the disciplinary committee of the Swedish Bar Association. Now, these actions raise issues of interpretation of Article 3.8 of the Aarhus Convention, and I will submit that the protection of lawyers of victims is an element of protection in this Article 3, numeral 8. Third, statute of limitations. The date of the injurious act as a measure, as a moment to start the clock. But however, in cases involving hazardous chemicals and wastes, latency periods for manifestation of clinical symptoms are the norm. Many years may pass, decades, before a person may exhibit symptoms resulting from exposure to hazardous substances. So when should the clock start? In the date of the injurious act? Well, this can leave victims without any remedy, or when a person is exposed to hazardous substance, to a hazardous pollutant, well, the person may not be that he or she is exposed or that the pollutant is indeed hazardous. Or when a person learns about the hazardous exposure. I will submit that the answer to this problem should not deprive victims of access to justice. A fourth and final observation is, why did the victims not apply to the European Court of Human Rights alleging denial of a fair trial? This would have tested the boundaries of standing for organizations if it had been the organization that had presented the application to the European Court of Human Rights. This issue is quite heatedly discussed in a very recent case of Cannavacciolo and others versus Italy, where dissenting opinions express their views on this matter. I will make the point that the interpretation of Article 9, numeral 2 and Article 9, numeral 3 of the Aarhus Convention suggests that there is standing for organizations. There's certainly nuances that I will not get into now, but given this interpretation, there's a possible role for Aarhus parties in promoting Aarhus principles, and they could do so in a message to the Council of Europe in regards to the ongoing discussions on the recognition of the right to a healthy environment, and including the role of organizations in this right's justiciability. So pivoting back to the process and timeline for my upcoming thematic report, a call for inputs is available on the mandates webpage that is administered by the Office of the High Commissioner for Human Rights. I will present this report to the Council in its 60th session in September, and I hope and trust that the conclusions and recommendations may be of value to the meeting of the parties of the Aarhus Convention to take place in November. Before concluding, I wish to also flag a good practice that is particularly relevant to cases involving exposure to hazardous chemicals and wastes. Often states and businesses argue lack of evidence of causation. But here, human rights jurisprudence has evolved to recognize that exposure to hazardous substances can give rise to human rights violations. In 2023, for example, the Inter-American Court of Human Rights decided the case of the inhabitants of La Oroya versus Peru. The court reasoned, under the right to health, that it is not necessary to prove a direct causal link between the victim's acquired diseases and their exposure to pollutants in cases where the evidence shows that certain pollutants pose a significant risk to human health, people have been exposed to such pollutants, and the state is responsible for failing to prevent environmental pollution. In a similar line of reasoning, earlier this year, the European Court of Human Rights decided the case of Cannavacciolo versus Italy and others. Cannavacciolo and others versus Italy, that concerns widespread pollution in Terra dei Fuochi, involving illegal dumping and burning, among others. The court reasoned, this time under the right to life, that the evidence of pollution and the residence of the applicants over a considerable period of time established a serious, real, imminent risk to life, which in turn triggered the duty of the authorities to act. The court thus did not consider it, and I quote, necessary or appropriate to require that the applicants demonstrate a proven link between the exposure to an identifiable type of pollution or even harmful substance and the onset of a specific life-threatening illness or death as a result of it. End of quote. Access to justice demands that national legal systems give effect to these pronouncements. This has clear implications for prevention, and so the role of regulation and other measures, but also for the burden of proof in judicial and administrative proceedings. And it is there that we're seeing the doctrine of the dynamic burden of proof, such as coming out from the highest courts in Mexico, in Argentina, in other countries, that place the burden of proving a fact on the party that is best placed to do so. The Escazú Agreement on access rights in Latin America and the Caribbean adopts this position as well. This has clear implications for access to justice. I'm out of time, so I wish to conclude by thanking you for the opportunity to join the 16th meeting of the Task Force on Access to Justice, and if I may encourage you to send input in response to the call for input for my upcoming report on access to justice and effective remedies in the context of toxics. Thank you very much for your attention.